Welcome to the world of elder law, estate planning, plus and more. This is about becoming elder wise, and you're going to discover it's not all black and white. Elder law is the most complicated area of a law on the planet. There's no logic, there's no rhyme or reason. It's a federal program. Medicaid is a federal program administered by the states. One needs to be an expert in the area of lifetime probate, guardian and conservatorships, protective orders, power of attorneys, probate upon death, taxes, Medicaid and Medicare, estate planning, ladybird deeds, irrevocable trusts, and veterans planning. You may ask, why does one need an elder law attorney? Well, you need it to navigate the minefield of Medicaid. Before we get going, let me tell you about myself and brag a little bit. I've been practicing a long time, 35 plus years, and this is my passion. Elder law, I've practiced in it. My practice deals with families that are dealing with dementia, Parkinson's, planning for when they have children that are young or old. You don't have to have a dime to get sick. The goal is to be proactive in planning. I have been the chairman of the board of the Alzheimer's Association for 6 years. I've been the chair of the elder law section for the State Bar of Michigan. I've been on the board of directors for the Alzheimer's Association for the last 30 years. I've been recognized by the Our Detroit, Detroit Business, New York Times, and Super Lawyers for 14 years in a row. And recently, the last couple of years, I've been recognized as one of the best lawyers in America in elder law and trust and estates. Enough about me. What are our goals and objectives and takeaways? I want you to understand the problems without planning. I want to educate you what you and your loved ones need to know about power of attorneys, ladybird deeds, and Medicaid and more. Answer your questions regarding your concerns, and dispel the myth that it's never too late to plan, even if there's a diagnosis of incapacity or dementia or Parkinson's. Explain the difference between estate planning and elder law, and we would love to be your inspiration to you and your family. So life in estate and long-term care planning is an act of love for yourself and your family. It's a way to preserve the assets so you can stay in the least restrictive setting, whether it's a home, assisted living, last resort of the nursing home. Avoid living probate, health directives, deal with incapacity planning, avoid probate upon death, whether it's joint ownership, beneficiary designations, or trust planning. Privatize your affairs. And let's make it clear, it's not about saving your kids' inheritance, it's about the quality of life. And through proper planning, you probably will save a legacy for your family. We need to protect against Medicaid estate recovery, and we want proper documents in place for loved ones to enact planning. So what are you going to learn today? We're going to learn the difference between estate planning and elder law. We're going to learn when it's the best time to start thinking about elder law. What are the most important documents when addressing elder law issues? If you already have documents, do you need to replace them? Can you give your assets away to qualify for Medicaid? Can the Medicaid program take your assets? How can you protect your assets from being spent to zero? And is this planning legal? Well, I'm going to tell you right now that I have the knowledge and the power to help you plan that if you're a married couple and if one of you were to get sick and need care in a nursing home, which nobody ever wants to do or go there, I could protect 100% of the assets. I could walk into every nursing home, go room to room and bed to bed, and protect 100% of your assets. If you're a single individual and you're not married, obviously, I could protect 50 to 70% of your assets. It's a complicated path. My takeaways today are basically, you have to understand that there are solutions to all these problems. So let's start. And it starts with planning for yourself. Have you done everything you should to ensure that you and your loved ones will be taken care of in the event of your disability, or when you're no longer here to take care of them? My favorite saying when it comes to planning, don't procrastinate, plan ahead. It wasn't raining when Noah built the ark. No one's going to tap us on our shoulder to go ahead and plan. We typically plan when there's a health issue for a family member. There's a huge news story about, something tragic, or your neighbor on your right, your neighbor on your left, or whoever's you're talking to says we did this or we did that. The goal, though, is to plan ahead. And when to plan? Now. There's no better time to plan than now. I'm going to state the obvious. COVID was our wake-up call. It's not over. We had plans this weekend, and the couple that we're going to go out with, they have COVID. So I want you to learn from the past. We should live in the present and plan for the future. I can tell you right now, I believe it's now more important than ever to plan. COVID touched our practice of law significantly. In the last 3 years, we had 83 people die from COVID themselves. So this is planning for today and the next 25 years. It's no one's promise tomorrow. And let's talk about planning for the unthinkable. So elder law attorneys, we think outside the box. We're estate planning attorney, and we kick it up several notches. And when we plan, and anytime I do a documents for clients and do an estate plan, I include elder law provision. And these provisions allow us to address whatever comes down the pike in the future, whether it's a nursing home issue, a family member needs care, someone gets incapacitated, we have to access IRAs, whatever the case may be. One of the most important most common plans that I ever do is the I love you plan. A married couple comes to me and they say, we want to plan for the future. So we plan for the future. And it's typical, and most of you have the same plan if you're married. If the husband goes first, the wife gets it. The wife gets it, the husband gets it. If they both go, the kids get it. Well, what if the husband has dementia or Parkinson's, can't live independently alone? The wife is the caregiver. What happens? Well, you don't really want to think about this, but 70% of all caregivers over the age of 70 go first. And if the caregiver goes first, that's unthinkable. My dad was a caregiver for my mom. He was 94, he passed away. My mom lived to 98. He was her caregiver. If the caregiver goes first, then all the assets go back to the spouse that can no longer live independently. Then all the assets go with that ill spouse, whoever they go. Assisted living, nursing home, and we've lost the ability to protect the assets to the extent that we could have had we done some planning for the unthinkable. So here's a typical situation. Husband and wife, they do their planning. One of them has dementia or Parkinson's. They can't live alone independently. The well spouse's health is declining because the caregiving takes its tremendous toll. They come to me and say, we need to address the current circumstances. And I say to the well spouse, if you go first, can your ill spouse live independently? If not, then we change the documents. And if the ill spouse is no longer competent and capable to make those changes, I have drafted power of attorneys that allow the well spouse to make the change. The change is their joint trust becomes the wife's trust. The wife's trust says if I go first, they have to stay in the trust. The kids can't touch it until dad's gone, but they can use it for his care, and legally they're the beneficiary. Dad's not the beneficiary. It's not available, or it's not an asset that's available or accountable for Medicaid. So that's thinking outside the box. What's our mission today? Well, the top paragraph is a mission for every estate planning attorney. And then as an elder law attorney, we add the following language. So I'm going to read it to you. I want to control my property while I'm alive, take care of my loved ones if I become disabled, be taken care of if I become disabled, and give what I have to whom I want, the way I want. And if I can, I want to save every last tax dollar, court cost, and professional fee and court costs possible. Further, if I have to go into a nursing home, which I never ever want to do so, I want the greatest quality of care and the least restrictive saying these costs to me and my family. Amen? So this is where the top half is the estate planning attorney. The bottom half is what the elder law attorney brings to the estate plan. So we do both. Put your house in order and start dealing with money, jealousy, control, second marriages. And now we have family feuds. It's not just a game show. Our law firm is a boutique law firm. We have 8 attorneys. All we do is deal with the issues when the family can get along, and we deal with pre-planning, proactive planning, crisis planning, but we deal with it from an estate and elder law perspective, trust administration, probate administration, guardian and conservatorship, and special needs. The other side of the law firm is when the family can't get along. We're fighting over money, jealousy, control, contested probate, contested trust, families fighting over who's going to have control of the loved one that's becoming disabled. So what is the difference between an estate planning attorney and an elder law attorney? First of all, elder law doesn't mean you're elderly. It means you want to be old one day. An estate planning attorney looks at the estate tax laws. Estate tax laws these days are not that important because your exemption amount between a married couple is about $30 million and or 26 million, and the individual is about 13 million. If you have that type of money, you're not going to look at elder law. You're going to look at paying for your care privately and probably at home care. Power of attorneys for health or financial. Do they become effective the moment you sign them, or do they become effective when you become incapacitated? 99% of the power of attorneys I look at, they become effective when 2 doctors or a psychologist will say you can't handle your affairs or participate, and then they spring into effect. Financial power of attorneys will limit the ability to make gifts, limit the ability to change estate planning. There is no long-term care language to protect your home if it's an irrevocable living trust. You have to understand, if a house is inside entitled into a trust, it is a countable asset for nursing home purposes. There is only one circumstance where I will ever put a house in a trust for a married couple, and we'll discuss that towards the end of the presentation. An elder law attorney deals with governmental assistance, so it's a natural that they will deal with special needs planning for children and adults with special needs. Estate planning attorneys understand they can't have assets over $2,000, so a lot of times they'll leave it to the well-able child, and hey, they'll have a moral obligation to take care of their brother or sister that is disabled. We look at the Medicaid, veterans, and estate tax laws. We want the power of attorney effective immediately for daily medical decisions. We want the power of attorney allow gifting for proper long-term care planning. If the house is in the trust under some circumstance, we want the house removed from the trust if there's a long-term care issue. We deal with, what if we can't stay in our home? How can we pay for it without going broke? And how do I get that greatest quality of care at the least cost to ourselves and our family? Life and incapacity planning. What is this about? It's about avoiding the living probate. If you're unable to make your reason-informed decisions or communicate them, whether it's care, custody, treatment, placement, end-of-life, day-to-day, or mental health decisions, you need a guardian. If you're married and you've been married 50 years, 60 years, 70 years, you need a guardian. You don't have the legal authority to make each other's decisions. You can't handle your financial affairs. You have to access a life insurance policy in your name, or IRA or 401k, or whatever the case may be, sign a tax return, and you can't manage your financial affairs effectively, then you need a conservator. Those processes for the probate court are optional. You can avoid them. We establish power of attorneys for healthcare and financial power of attorneys. So who makes our medical and financial decisions? How do we ensure that those people are going to make them when we want them to make them? And what happens if we're on life support? Just talked about conservatorship. You can't manage your financial affairs, you need a conservator. You can't make your personal decisions medically, you need a guardian. So The living probate. If one becomes disabled, unable to make their own financial medical decisions, you have a choice. You let the court supervise your affairs and lose control. And there's no limit to the cost or to the emotional stress and trauma. Or you can maintain control, put your wishes in writing, create an elder law power of attorney and a patient advocate, and keep control at a low cost. We're going to spend a significant amount of time on power of attorneys because that is the cornerstone of planning for your lifetime issues. All power of attorneys are not the same. This picture was in May 17, 2012, 11 years ago. Excuse me. And that happens to be my family. The woman on the shoulder with the sunglasses, my wife, Shelley. The other woman with the hat is my sister-in-law, Cookie. And that's their dad, Marty. In fact, we were talking about this last night. Marty, when he was in his 80s, his wife passed away. He was living alone and he was doing great, driving, managing all his activities of daily living. We saw no issues whatsoever. And one day we got a call from his clergy that Marty was sitting in the parking lot for the last month every night at 2, 3 o'clock in the morning, 4 o'clock, whatever the case may be, waiting for services to start. Marty was a very religious guy. He went to services every morning, 365 days a year. So we approached my father-in-law, my dad, and we basically asked him, why are you sitting in the parking lot? And his comment was, well, when I get up to go to the bathroom in the middle of the night, I get up, I get dressed, I can't go back to sleep. I get in the car and I go wait for services. I don't want to be late. Well, we told him it wasn't natural. So basically we devised a plan. There was 3 in-laws and 3 kids, and all 6 of us took turns. And we started calling him in the morning and telling him when to get up. That was great. Get up, Dad. It's time to get up, get dressed, go to service. And he did that. He did that great for about 6 months. And then all of a sudden, this phone call started. Is it time to get up yet? Is it time to get up yet? Is it time to get up yet? Well, I was walking around my office and life as a zombie. We couldn't get any sleep. I was president and chairman of the Alzheimer's Association at that time, and I swore that he had Alzheimer's. He had some type of dementia, and we couldn't put our finger on it. So basically, the family was slow on the take. So I took the control of the process since I was the power of attorney. And I made arrangements to have him worked up. Yes, everybody was resistant, but we did it. We did a workup at Henry Ford Hospital with a renowned neurologist who's no longer there named Rana Schatz. It was like a 6-hour workup. It was worth, there's Alzheimer's Association also had an office there. So it was kind of a wraparound program. And I was for sure that he had Alzheimer's. We sat down for the meeting, and the neurologist, Rana, says to us, he says, I want to do a sleep study on your dad. And I said, sleep study? He's 88 years of age. Why would you do a sleep study for an 88-year-old man? This is because something else is going on. So we did the sleep study. He went to a clinic. He slept out, put wires in his, on his head and a hat and things like that. And they found out he had one of the worst cases of sleep apnea that you could possibly think of. He was never sleeping. He never went into REM. His body never rejuvenated. He was having confusion, memory issues, all that type of stuff because he never slept. So we got him a caregiver. I did get him veterans benefits. And he got him a sleep apnea machine. And we got our dad back for about 3 years. We discovered, in addition to the sleep apnea, he had some type of Parkinsonism, and he had Lewy body dementia. He lived 3 years with some great quality of life. And then about 91, he passed away from the Lewy body dementia. Had we not had his power of attorney, I don't know what we would have done as far as, what the outcome would have been. Because the power of attorney was effective immediately, we were able to be involved in his care and not wait for his incapacity. What do you look for in a medical and financial power Well, let's talk about springing an effective immediately. I can't begin to tell you that 99% of the attorneys out there will draft healthcare power of attorneys for day-to-day medical care to be effective when you're unable to participate in your decisions. Right now, my wife and I have healthcare power of attorneys. They're effective immediately. I go to the doctor and I say to my wife when I come home and I say, I didn't hear the doctor. I was confused. I wasn't paying attention. I didn't understand, or it's none of your business. My wife would have the authority to pick up the phone and call the doctor. She can't make my decisions, but she surely could be a partner in my care. She can make my decisions if I acquiesce in this. So I think it's a much better way. My dad passed away at 94. My mom lived to 90, almost 98. And after my dad died, she was competent enough, but she was making poor decisions all the time. She even signed herself up for back surgery with the visiting doctor, unbeknownst to us, which I then canceled with their power of attorney. Is there an alternate list? Do you just point each other, or do you have kids or alternates available? Does it address right to life, right to withdraw life support and do not resuscitate? Does it cover mental health decisions? And a lot of elderly have mental behavioral issues when it comes to dementia or Lewy body or frontal temporal dementia. And does it allow us to address those circumstances? Does it cover the Health Insurance Privacy Act? Does it allow unrestricted gifting? And we're not talking about gifting to our kids. We're talking about gifting between husband and wife or the kids if we need to. Does it allow to amend, revise, revoke an existing estate plan? There's that very, very powerful power. The person's a fiduciary, but we give that authority and they have to act in your best interest under the circumstances. Does it allow us to establish a trust or an irrevocable trust? Caution, don't do it yourself or use a form. One size does not fit all. Does it allow for a PDF or a fax or a photocopy so you can just give copies to the doctors? Does it deal with digital assets and deal with specifically IRAs? Is it valid in more than one state? Are you a snowbird? That type of thing. Well, here's the proverbial. I'm going to offer you a free consultation. You can sign up now or email me at rosedr@brmmlaw.com. If you're listening to this and you want some more materials or a copy of the presentation, I'll be more than happy to send it to you, but I will password protect it. And I ask you, please do not share it with any other professionals and respect my request. So you can email me at rosedr@brmmlaw.com or go on the website and I'll be more than happy to send you a copy of this. So we just spent about a half hour on power of attorneys and the goals and objectives. So let's get into some of the meat in addition to what we talked about. We're living longer. Mark Twain said, if I'd known I was going to live so long, I'd taken better care of myself. Mickey Mantle stole it. Children born today have a 50-50 chance living to 100. 12% of 65-year-olds and 50% of all 85-year-olds have Alzheimer's disease, some type of related dementia, whether it's Parkinson's or whatever the case may be. 70% of all caregivers over the age of 70 go first. We have more parents today to care for than we ever have had children. There's more than double the annual spending on home care and nursing home care combined. Families take care of families. The majority of our money spent is uncompensated caregiving. So the cost of the uncompensated caregiving in this country in 2016 was $500 billion, basically. The government knows that. The government wants to give us some quid pro quo safe harbors of legal ways to plan, but they try to take it away all the time. So they're whittling them away. The cost of caregiving, there's 50 million Americans age 18 or older providing unpaid care to an adult. If you're a caregiver, you're spending $7,000 out of your pocket. That was in 2016, or 12,000 if you're out of state caregiver. In 2016, you were spending $500 billion. It's probably more now. How much will long-term care cost and how long will you need it? How long you'll need it is nobody has a crystal ball. The average stay in a nursing home is typically 2.5 years. A nursing home is about $118,000. In reality, it could be much more. Assisted living, you're talking somewhere between, $4,700 and $7,500 a month. Adult daycare, a couple grand. Adult foster care, which can be the best kept secret. You can pay $4,000 to $5,000 a month. You can live in a home with 4 or 5 other people similarly situated, have care there one-on-one, or one somebody there all the time. And it's a licensed adult foster care facility, typically within your neighborhood. Home care, because of the pandemic, $30 to $32 an hour. Look at that, 260,000, $250,000 a year to stay at home. I don't know anybody can afford that amount. Who needs long-term care? Well, it's not just for the elderly. There's 30% of the people that are younger than 65. I had a 39-year-old gentleman pass away with 3 young children from Alzheimer's disease. I've had several women with frontotemporal dementia in their 50s. I've had families with Parkinson's and ALS and at younger ages. Over 65, 2 out of 5, over 85, 4 out of 5. And if people turn 65, close to 70% will enter a nursing home at some time before they pass away. If you knew it was a 70% chance of rain, you would take an umbrella. If you knew there was a 70% chance of having some type of long-term illness, you would do your planning. But most people don't. How do we pay for care? We be rich, we be poor, we plan, or we be insured. Rich. You were born into money. You worked your butt during your lifetime. You inherited money. You won the lottery. You were blessed. Somehow, some way, you're able to pay for your care out of your income, interest, and dividends and not dissipate your principal very much. Or you weren't blessed. You go on Medicaid right off the bat. You can plan for Medicaid, accelerate the ability to qualify for Medicaid. Or you had the forethought, the health, and the wealth, and you bought long-term care insurance, which I call stay-at-home insurance. Medicaid. People say, I would never want to go on Medicaid. I never want to go on a Medicaid nursing home because it's substandard care. Absolutely not true. Most of the facilities in Michigan now have what's called dual certified beds. Each bed is Medicare and each bed is also Medicaid. For instance, the Wellbridges have a very good reputation. So does Lourdes. So a lot of the other facilities, they're all dual certified. They won't tell you. You typically get into a facility, they say it's a short-term rehab, but what they don't tell you is the money runs out, or if you intentionally keep the money, protect the money, you can stay there under Medicaid. So we have to plan very carefully. Everyone needs that health care and financial power of attorney with the gifting authority. Nobody wants to go to a nursing home. I've never had a client say, I really want to go to a nursing home. So what are the alternatives? Well, there's a home-based Medicaid waiver, expanded to adult foster care and home for the ages. If you're single and your income is less than $2,742, you can qualify. That means you have to have no more assets than a home and a car, a personal property, and a burial planning, and $2,000 in cash. If you're married, we can qualify for the spouse that their income is less than $2,742. There's assisted living, there's adult daycare, and there's adult foster care. Medicare was designed for the acute medical costs, only covers 2% of the long-term care costs. You need a hospital stay. If you're over 65 and you need Medicare, you want OT, occupational and physical therapy, you need to be admitted to a hospital for 3 days. Not observation, an admission for 3 days. That includes the day of admission, whether it's 11:59 p.m. and you're there for 2 minutes, that's a day of admission. The next 2 days, but never the day of discharge. It must be skilled or rehabilitative care. And even today, I was told by a client that their dad's in the nursing home under rehab, and the nursing home told them that dad can't stay there anymore because he's plateaued. The word plateau, or the reason for improvement, that someone has to show improvement, is not the law anymore. The law requires someone to prevent a slow decline if therapy stops or to meet their functional goals. This is a game changer. If you are listening and you are interested in this topic, Google the word JIMMO, JIMMO, or go on to centerformedicareadvocacy.com. This is a clearly difference in way therapy is delivered these days. Medicare pays for the first 20 days at the full rate. The next 80 days, there's a $200 copay. And after 100 days, there's no further benefit. You don't pay, you don't stay, or you go on Medicaid. Not many people get the 100 days. That's why you have to be an advocate in order to qualify for as much therapy as you possibly need. Typically, what will happen is your loved one's in getting therapy. They'll get a notice under Medicare within 48 hours that the therapy is going to be terminated, and you can appeal it. And typically, my clients will appeal it, and they'll get 2 weeks at a crack each and every 2 weeks. They appeal it, and they get more and more and more time, providing successful outcome because they're getting more therapy and occupational and physical therapy. How do we pay for care? Well, the nursing home game. Nursing homes want the healthy and wealthy patient. They try to discriminate between that Medicaid and private pay patient at the time of admission. They want a private ticket. They want you to come in and pay privately. When Medicare runs out, either you got to get out or you have to pay privately. It's not true. If you get in a facility and accept Medicare and accept Medicaid, if the funds run out or if you protect the assets, you can stay there. They can't kick you out. The quality of care is the policeman determines the quality of care. The squeaky wheel gets the grease. The quality of the baked goods will determine the care. My mom, when she was her last 8 months of life, she was in a nursing home in West Bloomfield. She was mentally fine. She was just physically infirm, couldn't really get out of bed without assistance. So we put a candy dish in her room, a huge candy dish, and we stocked it. And anytime anybody walked by her room, they'd grab a piece of candy or a treat. And my mom would say, oh, by the way, since you're here, can I have this, this, and this? And she would get the best care. We can implement strategies to protect assets for single persons, which is converting assets from countable to non-countable, called conversion, or we can do gifting in half a loaf, which I'll explain. Married couples, easy. We can go to court, which is not necessary anymore. We can convert from countable to non-countable. We can use the best thing since sliced bread called sole benefit trust or name on the check, which I'll explain. Medicaid planning, there's no system for the middle class unless you do the proper planning. It was designed for individuals who have no other means to pay for long-term care. But our government says, go broke and we'll give you a hand. It's not really the appropriate way to do it. We're probably one of the only free democratic countries in the world that don't provide care for our elderly. Michigan has a state recovery. They will cover the cost of care from your probatable assets. It's typically the home if it has to go through probate. Laws change constantly. There are revisions to policy every 4 months. The only constant is change. However, the pandemic suspended all types of changes until May 11th of 2023. And I expect we're going to see all types of changes after May. Benefit plan. What can go wrong? Well, you do planning and you violate the 5-year look back, which we'll explain. You misunderstood the 5-year look back. You waited too long, or you applied too early, or you paid for care without a proper care contract. You screw up your benefit eligibility. You disrupt your mom and dad's estate plan. You make mistakes in gifting assets. You confuse gifting for the IRS, which is $17,000 per year, and gifting for Medicaid, which is $17,000 gift, is a 1.7-month penalty. There's mandatory disbursements from trusts, or certain assets can cause difficulty with Medicaid eligibility. What can one keep if they go into a nursing home? A person in a nursing home keep $2,000 cash. They can keep their home if it's under $688,000 in equity and not in a living trust. If there's a spouse and they're married and the spouse is in the community and living at the house, there's no limit to the equity. All personal property and jewelry are protected if it's not used for investment purposes. One car, an irrevocable funeral contract set off by cash value life insurance. Burial space planning, which means anything but the actual funeral for the well spouse and all the children and brothers and sisters and their spouses. Kind of crazy thing to do. Special needs trust for children and adults with disabilities, and special annuities. So this is what a person can keep if they're in a nursing home and single, or the well spouse can keep this plus this. So the well spouse is entitled to special protection. And that special protection occurs at the snapshot date. And the snapshot date means is the last night the ill spouse slept at home, or really legally, it's the first day of 30 days of continuous care, which is the earlier of a hospital admission or rehab admission. Medicaid will look at the husband's assets, the wife assets, their joint assets, and any assets that are jointly owned with anybody else. Medicaid says that the well spouse can keep half the assets, and let's call it $150,000. So if a married couple has a home, a car, and jewelry, and $100,000 in assets, 50,000 is protected and 50,000 is at risk. If they have $500,000, 150,000 is protected and $350,000 at risk. I'll show you how to protect the at-risk assets. Income. The well spouse, whether they're working or not working or have all types of income from pensions and Social Security, they can keep all their income. I have right now a wife in the nursing home and the husband's still working and he makes $100,000 a year. He can keep all his income. He's also keeping all the assets, and I'll show you how. If the well spouse has $1,000 in income and the ill spouse has $3,000 in income, most of the ill spouse's income can be diverted to the well spouse because she's entitled to a maximum possible of $3,715 a month. Income and assets can be increased by court order, create a sole benefit trust, or by the name on the check. Married couples, what is the best thing since sliced bread? It's called the sole benefit trust. The sole benefit trust for the community spouse, the well spouse. It's a special irrevocable trust by the well spouse or the well spouse, using the well spouse's Social Security number. So that basically means that it's an irrevocable trust, but it's not a taxable event. So any stocks, bonds, mutual funds, real estate, or you name it, except retirement assets can be put in this trust without any tax consequences whatsoever. And the well spouse is not the trustee. One of the kids is the trustee. The trust says we'll pay it back to mom or dad over their life expectancy or less, and whatever's in that trust is protected. I could literally qualify Dan Gilbert for Medicaid if it was ethical and I had to. People say, well, this is never going to stand up. Well, it has. We used this for years. Then the state of Michigan says, you know what? This just doesn't seem right. We're going to deny him from this day forth. The elder law section, which I was a member of the council, or I can't remember if I was the chair at that time or not, we sued the state of Michigan, and it took 5 years. It went through all the courts. It went to the Michigan Supreme Court, and the Michigan Supreme Court said it's federal law administered by the states. Federal law allows this, and Michigan Supreme Court never does anything unanimously. They unanimously approved the sole benefit trust by the Michigan Supreme Court. So we don't think it's going away anytime soon. Could there be another challenge? Sure. But the bottom line is that this is something we can do. So in the situation right now that I'm working with, the wife's in the nursing home, he's still working. He's got a 401k. He has a home and he's got $600,000 in assets, which I didn't tell you. The wife's 58 and he's 56. So they're very young. She's got frontal temporal dementia. He can't keep her at home anymore. She's got some real behavioral issues. We're figuring out is where she's going to go, but she's going to be qualifying for Medicaid. We basically put the $600,000 into the $450,000 at risk into a sole benefit trust. His son is the trustee. With respect to his 401k, since he's still working, he can't touch it until there's a hardship of his pertaining to him, not his wife, and therefore it's not accountable or available. I had a situation where a married couple, the husband was in a nursing home on a ventilator. He basically could spend 12 hours a day off the ventilator and he could talk over it and write. He was competent. He just had a rare lung disease and 12 hours a day had to be on a ventilator. His cost of care was $31,000 a month, and that was about 10 years ago. They had a $1 million IRA. We basically annuitized the IRA for the well spouse. She was able to keep the income, all the assets, and he qualified for Medicaid. and he passed away basically 3 years later. And had she spent $30,000 a month, she'd be the Van Sack landmark case is a court defining the protection to increase income or assets by a protective order through the probate system. This was my case through the Court of Appeals. I won it because we have other options these days. It's not used as much as it used to be, but it's still out there. And this was my legacy regarding Medicaid planning. So is the next thing called name on the check. Next is the proverbial 5-year look back. Typically, Medicaid penalizes, excuse me for 1 sec. Typically, Medicaid looks back 5 years from the date that you apply for Medicaid. And it's not a 5-year penalty, it's a 5-year look. If we look and we find out that you sold or transferred or given assets away within the last 5 years, you get penalized. And let's call it for every $10,000 you give away, you're disqualified 1 month. You give a $400,000 away, you're disqualified 40 months. You give $10,000, you're disqualified 1 month. The thought is, had you not given the money away, you could have paid for your cost of care. Look back begins from the date of application, not the date of the gift. And if I give away $800,000 and it's an 80-month penalty if I apply at the 48th month, because then I applied within that 5-year period. So I can be penalized longer than 5 years if the application's timed improperly. It's unforgiving. All of these are considered gifts under Medicaid law. You give money to your granddaughter for college, your son who lost a job for food and shelter. You made a church donation if there's no long-term history of tithing to your church. You paid your daughter just to take care of her. So in this case, semi-healthy grandma gives 40 grand away. Grandma then has a stroke or severe dementia, pays privately for care, is out of money 2 years later. Then in October, grandma applies for Medicaid. She's not eligible. There's gifts within a 5-year period. She's going to be disqualified for 4 months, even though she's out of money. Who's going to pay for her care? Family, out of their pocket. Allowable gifts not subject to the 5-year rule, transfers between spouses. So if a spouse has $1 million in investment account, they can transfer to the wealth spouse. The wealth spouse can throw it into a sole benefit trust. It's protected. Transfer to a blind or disabled child. There's not a transfer. You can give all the assets you weigh away from you to your blind or disabled child. It may affect their SSI or Medicaid unless they're an SSDI, which is disability insurance. And it's not a 5-year look back. Your child is taking care of you in your home for up to 2 years. There's a doctor's letter that says that had that child not taken care of you in your home, you could not have lived there independently. You can transfer the home to the caretaker child. You can transfer to a child home to a child under 21, but that's kind of risky. You can transfer a home to a sibling with an equity interest in the home who's lived there for at least 1 year. And you can transfer for a purpose other than Medicaid to obtain SSI and Medicaid. However, the presumption is you did it to obtain Medicaid. Good example is Joe gives money to his 2 children to go buy homes, gives them $200,000 each. He's fine. A week later, he has a stroke, has to go in a nursing home, basically had no history of any medical issues. He was younger. That's probably not going to be considered a gift under Medicaid because he did it for another purpose. When you start gifting, you got to look at your tax deductibility of the cost of care. Can you deduct in spending down the assets, deduct the medical expenses over 7.5% of your adjusted gross income? When you gift assets, if it costs you $1 and you give it away and it's worth $100,000, your family will lose what's called a step-up basis upon inheritance. If they sell it during their lifetime, they have to pay the capital gains. If you give away IRA money, it becomes a taxable event. And then you got to really be realistic and look at the life expectancy of the nursing home resident. Is it available? This is a little known exception. I'm not going to tell anybody that's listening to go put your kids' names on the assets and wait 5 years. But let's say you put your kids' names on the assets years ago. It's a joint account and you need both signatures to liquidate it. It was over 5 years ago. You go in a nursing home, your son can or your daughter can say, hey, I'm going to sign an affidavit that that asset cannot be liquidated without my consent. I refuse my consent, and therefore it's unavailable for Medicaid. If the asset has the word or, it's a joint bank account or joint assets, and it doesn't require both signatures, then it is an available asset for both of you, both owners. The goal is to obtain the best quality of care in least restrictive setting. How do we protect the assets? We want to spend them for good care or services. We can convert from countable to non-countable. We can gift under the half a loaf, and we can do the married planning. Conversion, buy a new home, improve or repair an existing home. If the husband's in a nursing home and the wife's in the community and she sells the house, they never look at her assets again. She can win the Powerball. She can sell the house and keep the cash. Once one spouse is qualified for Medicaid, they don't look at the well spouse's assets. Pay off a mortgage, any other debt, buy a Medicaid-friendly annuity, establish special needs trust, establish a personal service care contract or a home care contract for someone to take care of you. Gifting and divestment outright, it's the easiest. It's the most dangerous. It's the cleanest approach. You give assets to your kids, you're at their mercy and you lose control. Give assets to your kids, they become consequences. Give assets to your children, their problems become your problems. It's fraught with issues. So let's look at some strategies for a single individual by using gifting. Dad's got $330,000 in assets and $3,500 in income. He's widowed. Got dementia or Parkinson, needs nursing home care. He has a home worth $200,000 and $330,000 in assets, $35 a month in income, $10,000 cost of care. He needs $6,500 a month for getting the cost of the home to keep it up. Well, you can see if he doesn't do anything, he would spend $6,500 a month to be broke in 46 months. What he does is he gives $200,000. Let's say he's incompetent. Son or daughter has the power of attorney. They give themselves $200,000. They can put it in their bank account, or they can create a trust and says it'll be protected from our problems, and we won't touch it till dad's gone or he needs it. And we give $200,000, which is a 20-month penalty. The home, that $200,000 can support the home, or they can rent it, and 65% of the rental income is considered exempt. Dad can't qualify with $130,000 in his bank account, which he didn't give away. So we convert the $130,000 to income that will pay 20 months at $6,500 a month. How do we do that? Pretend you have a freezer in the corner. You put the $130,000 in the freezer. We weld the freezer shut. And once a month, we go out and get an ice cube or $6,500 a month in check. That's called an immediate annuity. When that freezer is empty, we apply for Medicaid. Well, actually, we apply for Medicaid immediately to trigger the penalty. When the freezer is empty, the penalty expires. They take us $3,500 a month in income, and Medicaid pays the balance. So without planning, we're broke in 46 months, and with planning, we're eligible in 20 months. We save 66% of the assets under this scenario. This strategy works no matter what the income is and what the assets are, as long as the gift isn't longer than your 5-year penalty. Gifting works, but it should always be done with the assistance of an elder law attorney. Why? Well, there could be disqualification years later. You give money to your daughter, and she gets divorced, and half your assets go buy your favorite soon-to-be ex-son-in-law, the new BMW or whatever. You're not going to like that. Financial difficulties. Everyone has financial downtimes. Your daughters think I'm going to inherit the money anyways and spends it. Your son thought it was the best stock pick of the century and the market crashed. You wanted to pay your daughter for your care. Who knew you had to have a written, notarized care contract supported by a doctor's letter? If you're paying for care privately to a agency or non-agency, relative or non-relative, you need a written, notarized care contract supported by a doctor's letter. College financial aid. Your grandson's not eligible for financial aid because you shifted assets to his father. The stock you gave your son cost you 10 grand. It's worth 100,000. Your son eventually sells it. He's got the capital gain based upon the fair market value when he sells the stock. The unthinkable happens. The money you gave to your children, they predecease you. Now the assets are in the hands of your in-laws. And more likely, these will all result in a penalty for Medicaid. We have a newsletter. You're more than welcome to go on our website or send me an email. Our website again is brmmlaw.com, or you can email me at rosedr@brmmlaw.com. And I can tell you right now, there's always changes. I expect some litigation regarding care contracts, promissory notes, and possibly a new attack on SBA. Be careful of the subtle gifts. These are all considered gifts under Medicaid law. Gifts to a charity, children, and organizations. Set up a joint bank account with the child and remove the parent's name. Add one of your kids' names to an investment account. That's a gift. Do a quick claim deed to a child and put it in a drawer. It's considered a gift. The college fund for the grandchild, it's a gift. $17,000 IRS permissible gifts to children are considered gifts. And more importantly, paying a caregiver without a proper notarized care contract is now considered a divestment or a gift. All states have estate recovery. Michigan has it too. I wrote the law with a couple other attorneys, with Senator Henson Clark in 2007. In 2010, the federal government approved it. It's a probate-only estate recovery. Some states recover life insurance, joint ownership, you name it. We only recover things that go through probate. There's exemptions if the house is occupied by the spouse, there's a child under the age of 21, a caretaker relative, or a sibling that's also a joint owner. You can avoid estate recovery by doing a Lady Bird deed or enhanced life estate or transfer on death deed, but you gotta plan ahead. A Lady Bird deed is a deed where you basically own the property to be able to do whatever you want with it without the consent of anybody else, whether it's a married couple, owning a husband and wife, where one passes, the other one owns it, or a single individual. And basically it says we own the property, do whatever we want during our lifetime, but if when we pass away, we still own the property, there's a beneficiary to the deed. It could be a trust, it could be your kids. There's no probate, there's no capital gains, there's no estate recovery, there's no Medicaid gift consequences, there's no uncapping of the property tax. Home is still protected asset under Medicaid. A husband and wife, basically, their individual creditors can't touch their assets, which is tenancy by entirety creditor protection. The grantor of the deed does not share in the problems of the future beneficiaries. And instead of naming one child, you can name the children, you can name a trustee, and that one child would then have the authority to sell the home and split the assets between the kids. So typically my clients will do a trust and name the trust as the beneficiary of the deed. It avoids estate recovery, and it's still a protected asset. Long-term care planning, contact an elder law attorney. You don't go to a podiatrist when you have a heart problem. All attorneys are not the same. These Medicaid laws change constantly. If you have estate planning done ahead of time, make sure the documents are done correctly. They should have long-term care language. If a nursing home is appropriate, make sure your loved one's in that private pay Medicaid dual certified facility. Evaluate long-term care insurance or hybrid long-term care. You have a policy, have it reviewed. You don't have one and can afford it and have the health to acquire it, you can explore it. You don't have to buy it, but you should explore it. If you have documents out there and you want them reviewed, we'll review them for you. We're going to wrap it up shortly. We're going to do some long-term care case studies. I'm going to read a story and give you the top 10 reasons why anybody should go see an elder law attorney. Very simple. Buy long-term care insurance or hybrid long-term care insurance while the benefit's paying for the nursing home care. Make a lump sum gift of your assets. The maximum penalty is 60 months. Medicaid applications properly filed on the 60th month after 5-year long-term care policy benefits expired. Medicaid takes over. Wait that 5 years and a day and apply for benefits, and they can't look at the gift. House in the trust, house out of the trust. Remember I said I would never put the house in the trust unless under this one particular circumstances. This is proactive planning for a married couple with little assets in a home. I met a couple today. They have a home and $100,000 in assets. And one of the spouses is ill. Basically, if the spouse goes in a nursing home, 50% is protected, 50% is at risk. We would have to do a sole benefit trust or whatever the case may be. I recommended we do a simple living trust, put the house in the trust because the house now becomes a countable asset. Here's the example. Bob, 70, early diagnosis of Alzheimer's, physically okay, mentally competent, nursing home in the future. Mary, 67, physically okay and mentally competent. They have a home, $200,000 and $150,000 in assets, basically. They have $2,500 in income. Bob and Mary proactively established an estate plan. We completed the healthcare power of attorney, power of attorney to a gifting authority, the living trust. Put the house in the trust, it became a countable asset. We asked for the allowance 10 years later when Bob went into a nursing home. And basically, because the house was in the trust, we took half of the 350. That was basically 175. They had 150,000 in assets. So I said to Medicaid, now you see the house, now you don't. So the protected allowance was 50% of the countable assets, or in this case, the max was $150,000. We took the home out of the trust. The home was protected. Mary did a ladybird deed to protect them from estate recovery. Mary kept all the assets, the home, all the income, as well as her own. We did a trust where most attorneys would say they didn't have enough assets to do a trust. In this case, we did it. So now I was Houdini. Now you see it. Now you don't. Married couple, married 50 years, have assets of home of $370,000, $400,000 in assets, $1,200 in income. The home at $150,000 is protected. Cost of care is 10 grand a month. Mary needs another money to live on, so they're short 9 grand a month each and every month, including that, which that takes into consideration their income. We applied for the protected allowance. The home at $150,000 is protected. $260,000 at risk. Without any planning, Bob's eligible for Medicaid in 40 months. With planning, we do the sole benefit trust, and we're protected immediately. Same scenario, except they have $600,000 assets and $400,000 in an IRA, and they've got basically $7,500 in income, and the shortfall after living expenses is another $7,500. We apply for protected spousal allowance. The home and $150,000 is exempt. The at-risk assets are $460,000. Without any planning, Bob's spent everything in 61 months. With planning, Mary keeps the home, all the assets, her income, her Social Security pension. She does not have to liquidate Bob's IRA. She annuitizes it with her name on the check. She gets $3,500 a month for 10 years. She establishes a sole benefit trust for the bank account investments, and she annuitized the name on the check to herself from Bob's IRA, and Bob was eligible for Medicaid immediately. In this case, because Mary increased her income to $4,500 and $3,500 from the IRA, that's $8,000 a month. Bob's income would go to the nursing home. You get what you pay for. The business of paying for an improperly designed estate plan will remain long after the sweetness of the low price is forgotten. I want to thank you for the privilege of your time in attending this webinar. I hope that you found it very valuable, opened your eyes, and opened doors that there are solutions to all these problems. And you can plan ahead proactively and protect your assets. Again, you can sign up for a consultation or email me at rosedr@brmmlaw.com. This is where I would ask you if you had questions, but since I'm doing this as a webinar and taping it. Obviously, you can't ask questions, but if you do have questions, feel free to email me. So why would anyone want to go see an elder law attorney? So I've been Don Houdini Rosenberg, and now I'm going to be Don Letterman Rosenberg. David Letterman, when he was at his show, could read the top 10 list. Well, this is the top 10 reasons why you need to see an elder law attorney. My husband, my wife, my loved one has just been diagnosed with Parkinson's, arthritis, Alzheimer's, or some type of ALS, or something that's going to be progressively worse or have some health challenges. Go see an elder law attorney. You have a Medicare supplement policy and you believe it will cover if you need long-term care. Go see an elder law attorney. Number 3, you called the Medicaid office. You asked about your rights under Medicaid. You called 3 times. You got 3 different answers. You talked to your neighbor on your right. They said one thing. Neighbor on your left said another. Neighbor on your across the street said, oh, yeah, they're all wrong. Go see an elder law attorney. You become incapacitated. You think your children will know what to do. At this point, I think you would run to the elder law attorney. You decide to give your assets to your children and wait 5 years. I would run faster to the elder law attorney. You don't need to do that. Your spouse has just entered a nursing home and you didn't plan ahead. There's nothing that you can do because you believe you have to pay the nursing home bill month after month after month. Go see the elder law attorney. You've been caring for your parents for the last 3 years. Dad has taken a turn for the worse and the doctor says he needs to go to a nursing facility. Mom is having some health issues. She may need to go to assisted living also or need care at home, and you want to care for them. Go see the elder law attorney. You have a child with a disability who lives in a group home. The greatest worry in your life is what's going to happen to my child with special needs after I'm gone. We specialize in special needs planning. Go see the elder law attorney. Your brother or loved one was severely injured in an auto accident. The other driver's at fault clearly. His insurance limits are 100 grand. Your loved one's going to need care for the rest of your life, their life. Go see the elder law attorney. And finally, very simple. You want to grow old one day on your own terms. That's why we all see an elder law attorney. Now, what's your greatest threat to your future and security? I'm going to tell you. I'm going to illustrate it by telling you a story. I've done these presentations for decades. I've read this story at every presentation, and I've been unable to memorize it for some reason, and you'll understand why. This is a little story about 4 people named everybody, somebody, anybody, and nobody. There was an important job to be done, and everybody was sure that somebody would do it. Anybody could have done it, but nobody did. Somebody got angry about that because it was everybody's job. Everybody thought that anybody could do it, but nobody realized that everybody wouldn't do it. It ended up that everybody blamed somebody when nobody did what anybody could have done. The greatest threat to our future and security is your procrastination or not going to an elder law attorney and doing it wrong. This is not a dress rehearsal. You need to get it right the first time. I want to thank each and every one of you for the privilege of your time in attending, and that will conclude the webinar. Stay safe, be well, and care for your loved ones. Take care.